organized by the Faculty of Law and the Faculty of Psychology and Neuroscience of Maastricht University and by the Law School of Leiden University. The main goal of these webinar series is to provide a critical insight into the current law and practice of pretrial detention, mostly from a comparative point of view. And just a few words to set the scene. In the last few years, pretrial detention has been the subject of increasing attention by both scholars and practitioners, and there is wide consensus about that pretrial detention is being excessively used. In Europe alone, just to mention a few figures, 1 out of 4 prisoners is held in custody without a conviction. What's even more problematic, however, is trying to understand the reasons behind this phenomenon. In our view, an exhaustive explanation of these trends can only rely on an interdisciplinary approach. And while the analysis of the relevant legal frameworks is crucial, it is, however, probably not sufficient to understand completely why pretrial detention is being overused. And so we need to combine black letter law with a comprehensive, a broader understanding of the legal and social reality in which pretrial detention operates. And so in keeping with this interdisciplinary approach, today's seminar has, in fact, 2 panel sessions. The first one is devoted to comparing procedural models in the use of pretrial detention, and it's going to start right now. And the second session is devoted to analyzing decision-making in pretrial detention, and it will kick off after a short pause at 3:30. So please stay tuned. But now, because today's program is extremely rich, I will, without further ado, give immediately the floor to Professor André Klipp, who is going to chair the first panel session. So, Professor Klipp, over to you.
Yes, thank you very much, Adriano Matuffi. Ladies and gentlemen, it's a great pleasure to welcome you at this panel, and it's even an honor to present to you the panelists of today. The first speaker of today is Professor Christina Morgenstern. Professor Morgenstern is, as of tomorrow, a professor of the Free University of Berlin. She has published extensively on pretrial detention, both on German procedural law as on in a comparative manner. The second speaker is Professor Jan Kreins. Jan Kreins is Professor of Criminal Law and Criminal Procedure. He has published extensively on Dutch criminal procedure, and he's also working in practice as a judge in the district court in North Holland, as well as the Court of Appeal in Den Bosch. And last but not least, we also welcome Emeritus Professor at Cape of the University of the West of England. At Cape has published on pre-trial detention and on the rights of accused, especially at police interrogations extensively. And he also has worked in practice, has been a practicing solicitor for many, many years. Without further ado, we'll give the floor to Professor Morgenstern, and I'm very much looking forward to her speech. Professor Morgenstern, you have the floor.
Okay, thank you very much. I'm trying to share my slides, but it says that the host is not allowing me to do that, so it would be good if I could do it.
Normally you have access.
Now it works. It works now. Okay, so it should work now and you should see something. So hello, everyone from Germany. Thank you, dear Leiden and Utrecht teams, for organizing this series of events, and thank you very much for having me. I will now talk about judicial decision-making on pretrial detention in Germany, and I will focus on grounds for detention. And my presentation is based on 2 research projects. The first one was funded by the German Research Agency, and that was a comprehensive study of law and practice of pretrial detention that focused in Germany, but that also compared vertically. So what standards do we have in Europe? How does the European Union impact on that subject? And it also compared horizontally to other European jurisdictions and their practice and problems. And the second one also was a comparative endeavor with 7 partners all together, led by Walter Hammerschik from Vienna and myself. And that project was funded by the European Commission. And it was both theoretical and empirical and had a qualitative approach. These are the 7 partners. And currently we're working on an update that should be published later this year, hopefully. But we also have a website where you can see technical and research reports. So the German study for Detour already could build on what I did before on the former theoretical study. And empirically, it was a 2-step research. In the exploratory empirical phase, I had a look at files of closed cases in which pretrial detention had been ordered, and I observed some pretrial detention hearings, which are not public in Germany. And in the second phase, I conducted 31 semi-structured interviews with legal practitioners, judges, public prosecutors, and defense lawyers, and also some prison officials in different German regions. Our research background, or my research background for both studies, is legal theoretical and for the second study empirical. So for the legal theoretical background, human rights are the main point, and both studies are based on the assumption that pretrial detention is a means of last resort because of the importance of personal liberty for all human beings. So ultima ratio, therefore, is the leitmotif. And of course, we have to ask what ratio, so what purpose pretrial detention has in the different jurisdictions. We know under Article 5 of the European Convention of Human Rights, detention is allowed before a conviction only under limited conditions, mainly to secure an orderly criminal procedure and ultimately a fair and legitimate outcome. But we also know that pretrial detention for the purpose to prevent the committal of an offense is possible under Article 5 of the convention as well. And these 2 aspects are also the 2 purposes accepted by German law. The European Convention on Human Rights does play a role in German jurisprudence, and to a certain degree, it also has influenced domestic legislation and reform. But much more important are the fundamental rights of the German Grundgesetz, so the German Constitution, and the jurisprudence of the Federal Constitutional Court. And this court has shaped German law and practice on pretrial detention considerably. I'm saying this here also because generally the Federal Constitutional Court plays a very important role for German legal culture, and in particular regarding its jurisprudence on fundamental rights. People do not always agree, often they don't, and some find that its role is too big, but anyway, fundamental rights is something you live with as a German lawyer from university to judicial practice. And we also heard this in the pretrial context from the practitioners we interviewed. Our approach also was based on criminological backgrounds, other research, social legal, social psychological research, but I won't, for time reasons, won't talk about that, just to assure you that we had such a background as well. So all this flowed into our research questions. And of those research questions, 3 are important here today. So normative prescriptions tell us that pretrial detention must be a means of last resort. Is it in practice? Is the law as it stands sufficient to implement the principle? And do legal practitioners show deficits in their practice? And I will, of course, discuss that in a moment. But before that, I will give you some more factual context taken from statistics in Germany and updated for today. So a classic piece on pretrial detention in Germany would always include the accusation that it is ordered too often, too quickly, and too long. This ever-repeated sentence dates back to the 1980s. But when we look at the development since the early 1990s, and this is when we have data for the reunified Germany, then for a long while, it seems that things have developed for the better. The number of pretrial prisoners at a given date was divided in half between 1995 and 2013. We can then see a relatively strong increase until 2018, most probably because of many migrants coming to Germany in the so-called refugee crisis. Indeed, there was an increase of offenses committed by foreigners, also against foreigners. And there was an overall crisis feeling, including in the criminal justice system. Data for 2019 now show a decrease that is still unrelated to the pandemic, because the data is from March 2019, and the 2020 numbers now have gone down, but that most probably has to be interpreted in relation to the pandemic, and we have to see where the trend goes. So for a while, the trend of detention was looking quite good in Germany, and also in a European comparison, the rate of pretrial detainees per 100,000 inhabitants as a comparative figure is relatively low and well below the European average. Relating to the presumption for liberty before or during trial, we could also argue that only a low percentage of all those convicted or acquitted, so of all those with a final decision in a criminal court, so that this percentage is relatively low. And we could say that this speaks for the presumption of liberty during or before trial. However, this rate is for all cases, and of course it is depending strongly on the offense, and it also has been considerably lower. In 2014 it was 2.4. So yeah, that's a question whether you want to say this is still a low figure. In any case, other statistical indicators are less rosy. For example, we have very strong regional differences within Germany. If you again look at the rate per 100,000, so you have 16 for Germany, but the rate within the region differs between 8 and 28. And this, of course, can be due to different demographic structures and therefore criminal structures. But it also is a sign of different judicial cultures, and can this be a fair judicial practice? This can be doubted. We also find still quite a share of relatively long pretrial detention durations, and also in an ex post view on proportionality, we find a picture that is well known in other countries as well. Only about half of all pretrial detainees receive an unconditional prison sentence, and everybody else is released with something else. And the most important point, I think, we have a very strong overrepresentation of suspects without German passport in pretrial detention, and depending on the region, up to 3/4 of all of them are foreigners. The German average in 2017 was more than 60%, and this has risen dramatically in the last 15 years or so. It is difficult to say that exactly because we don't have official statistics. So it's only studies conducted by us, or in one case by journalists, to see what the data are. And under the Freedom of Information legislation, a recent study looked at the pretrial detention ratio. So this is what I said before: 3.3% of all people with a final decision in a criminal cases have been in pretrial detention. So I call that the pretrial detention ratio. And this differs significantly between Germans and foreigners, between 2% and 6.5%. So this is another indicator for overrepresentation. Now turning to law and practice of ordering pretrial detention, some more legal details. The German Code of Criminal Procedure holds two cumulative prerequisites for pretrial detention. There needs to be a strong suspicion, and there needs to be a ground to detain a person. And additionally, pretrial detention may not be ordered if it is disproportionate to the significance of the case or the penalty or measure of reform and prevention likely to be imposed, so the sanction. So this is what the law states. The four grounds accepted for pretrial detention are the flight or the risk of flight or risk of absconding, the risk of collusion or tampering with evidence, the risk of repeating or continuing illicit offense of a relatively serious nature, and the gravity of the offense, although this is not a standalone ground, as the Federal Constitutional Court has said in 1965. As for practice, again, a statistical glimpse showing here on the right side. The risk of absconding is by far the most often applied, accounting for 92% of all impositions of pretrial detention in 2019. Either this stands alone or less frequently is combined with other grounds this is possible. Less than 5% of all pretrial detention cases were those of the risk of tampering with evidence, and only 3% were those of the risk of repetition. While the dominance of the risk of absconding has there been forever, it is interesting that the risk of reoffending or repetition, according to the statistics, has even lost significance over the last years, even if we in Germany too speak of an era of prevention in criminal justice. So this is probably due to the fact that I mentioned earlier that we have a lot of foreign suspects, and there the risk of flight is always the first choice. In our research, we tried in the interviews to deconstruct the judicial decisions and find the real motives for ordering pretrial detention, particularly with regard to that dominance of the risk of absconding. When reflecting the reasons for this dominance, some interviewees hinted at the legal construction that makes the ground the easiest to operate. Indeed, the legal prerequisites for the risk of repetition are much more elaborate and harder to handle, and the risk of tampering with evidence often is harder to prove factually. So this is why, as these guys said here, in the end, usually it is the risk of absconding. Many respondents or many of our interview partners did not reflect on the choice of grounds very much. One judge simply expressed the need for pretrial detention, emphasizing the legal aim of the arrest warrant. So this person said, pretrial detention, in the first instance, it secures the trial, and in second instance, the execution of the sentence. This means when I have to fear that there will be no trial at all, with whatever result, I principally have to keep him here. And a remark by a public prosecutor shows that therefore a ground for detention always has to be found, the risk of absconding being one that one could then construct, so easily construct, even if it's not there. What is the risk of absconding legally? By legal definition, it's a higher probability of the suspect staying away from the criminal procedure than of him or her taking part. It thus only requires a 51% probability of his or her absence. Behind this rather low thresholds, its factual basis is tenuous, since it is widely accepted that there is no need for any flight preparations. Instead, just possible obstacles and motivating factors for flight are attributed to that person. And these attributions are supposed to rest upon professional expertise, but criminology, as I would argue, is the proper science, in fact does not supply any reliable findings on that. Despite that, legal scholarly science provides a highly differentiated and worked off catalog of requirements for an appropriate and thus lawful judicial prognosis for the individual's risk of absconding. And this catalog includes numerous incentives and obstacles, such as social bonds, relationships, children, work, personally related criteria, illness, mental instability, behavior in criminal procedures, contacts abroad, and also offense-related criteria like the type of offense and the expected sentence. So this altogether promotes sort of a comprehensive checklist of circumstances. Older empirical research, however, showed that courts do not cope well with that elaborate catalog or construct, and detention judges focus regularly on only very few criteria, most importantly, the length of the expected sentence and the social status, and here namely the housing situation. And this was fully confirmed by our research. Only few people reflected on the problem of forecasting certain behavior. So this person said that it's a balance between the expected sentence and the personal circumstances. I have to predict, and this prognosis in the end cannot be checked. If I leave him inside, we will never know if he absconded. And if I let him out and he bunks off, there are such cases, but not very often. It must be stressed that in Germany, as elsewhere, the decision by judges is prepared, if not anticipated, by public prosecutors. And this has been yesterday mentioned by Ilsa from Fair Trials. And it is true that also German research and also our research showed that by far the most arrest warrants requested by public prosecutors are indeed granted. We estimate that 90% are granted. But perhaps public prosecutors do request cautiously. They have, according to the law, the same duty to restrict their requests according to the ultima ratio principle. And indeed, we found some evidence that they could not only be drivers for pretrial detention, but also those who can curb its use. First of all, we were told that detention means work. So, because the decision has to be followed up, besides the usual casework, detention cases need to be treated more speedily, etc. And secondly, some public prosecutors showed more restraint in their decisions, whether they would request detention than we thought, and also sometimes more restraint than the judges. Among lawyers, the dominance and the poor reflection of the factual risk of absconding prompted a lot of criticism. They pointed to the stress and financial burden of actually fleeing or living underground and said that this risk was grossly overstated, as we can see here in the last quote. Focusing on the two dominant factors or motives for ordering or justifying detention with the risk of absconding, we have the length or harshness of the expected sentence, and this played a huge role. Judges speak of a perceptible sentence that could motivate absconding. And of course, we wanted to know what is a perceptible sentence. And overall, it's a dilemma in itself. How could you say something about a future sentence in an early stage of the procedure? This is a bias for everything that is yet to come. Anyway, we tried to find out what length of sentence the practitioners had in mind, or what were their experiences. So we asked for that, and we got very diverse answers. Apart from those that said there is no fixed rate at all, and that it always depends on the circumstances of the single case, others at least gave an impression on what their quantitative ideas for never pretrial detention or always pretrial detention was. And these ideas or impressions were diverse, as I said, between 6 months and 5 years. So judges said, I think about it as a perceptible sentence when it's 1 year, at least when it's not suspended. Others said it's 5 years, and public prosecutors sometimes start at 6 months thinking that this is a perceptible sentence. The question about expected sentence as a factor in the pretrial decision sometimes played also a role for proportionality considerations. So we have a very low 6-month threshold in the law, or others considered that the expected sentence could be suspended and said if it could be suspended, then I would not order pretrial detention. So these two things were particularly important in this interview, or for these interview partners, when they would not order or request pretrial detention. But important restrictions transpired, and this can be seen here by the quote of one judge. For trivial offenses, the arrest warrant is out of the question, except you have definite indications for flight or such a situation of neglect, that means no social bonds, that you have to say you can't seriously conduct the proceedings at all. So this means that proportionality considerations are, at least for some people, overridden by the commitment to secure the proceedings and actually enforce the law ultimately, therefore also for reasons of general prevention. Yeah, I see that my time is running, so I will try to be brief. So the second factor that is always very important, apart from the expected sentence, is the housing situation. So somebody who has no address, the court can send their summons to, or the police, then there is a heightened risk to be put into pretrial detention regardless of offense and proportionality considerations. And that of course means that foreigners without fixed abode in Germany, in particular when they are socially not integrated, can hardly avoid pretrial detention. A common feature of critical works on pretrial detention in Germany are unwritten or extra legal grounds for detention, and I have listed some of those typical examples here. I will jump to that point because it relates to the statements and questions Adriano and Christina have given us. What I found surprising was that individual preventive reasons to prevent a defendant from further offending did hardly play a role in our interviews. And we assumed the contrary. And there's also some evidence, at least for young defendants in the German literature. We assumed that even if officially pretrial detention was based on the risk of flight, behind it we would be able to detect the wish to prevent further offending by this very defendant. But this was not the case. And maybe we can discuss why. I have some ideas why this was not the case in our interviews, but that's a clear finding in our research, or in my research, that preventive reasons played a lesser role than I thought. Coming back to the risk of absconding, we saw that many practitioners sometimes simply want to have the suspect available, regardless if a real risk of absconding can be substantiated. And in this way, the overestimation of the risk of absconding could be seen as a latent apocryphal or extra-legal motive. So the key questions we were kindly asked, or were asked, and I think that's a very good idea to answer, is the following statement: pretrial detention is mostly a measure geared to secure the presence of the defendant at trial. Other grounds of detention are marginal in the law and or in practice in your jurisdiction. So I think I've answered that. It's not marginal, but it's a lot less important. Grounds for detention aimed at preventing reoffending are the main cause of overuse of pretrial detention in your jurisdiction. Again, I think this has become clear. No, they may play a role, but it's not clear from, or there's no evidence that they play the dominating role. And the last question or statement was the most difficult. Current procedural rules allow judges too much discretion to order or extend pretrial detention. This can be solved by amending the statutory framework, for example, by posing more constraints on judicial discretion. So this is more difficult to answer. So I would cautiously say rather yes, it would be a good idea to have stricter thresholds, because that would help to avoid pretrial detention for petty offenders, for foreigners in particular. But I think that restraint in that case rather has to do with judicial culture. So we have to work on that, and foreigners remain the unsolved problems. So thank you very much for your attention and patience.
Thank you so much, Professor Morgenstern, for your most informative presentation. That was very, very informative, and it has already led to many questions. What I forgot to mention to the attendees is that you are free to mention all your questions in the chat. That will now, for instance, allow Professor Morgenstern to look at the questions that are available. And at the end, after the third presentation, we will have the panelists responding to the questions. So don't hesitate to mention your questions in the chat. Then I will immediately give the floor to Professor Jan Kreijns for his presentation. Jan Kreijns, you have the floor.
Yes, thank you very much, André. And thank you very much for inviting me to this conference, to this webinar. I'm glad so many of you decided to attend, since pretrial detention is an important but difficult issue in a lot of European countries, and this is definitely also the case for the Netherlands. As I will explain during the upcoming 20 minutes, pretrial detention is a quite heavily debated issue in the Netherlands over the last years. The Dutch system also faces various challenges in light of the case law of the European Court of Human Rights. And today I will focus on 3 specific problems. The first problem is the extensive interpretation of the legitimate grounds for pretrial detention. The second is the lack of reasoning of pretrial detention decisions, and the third is the lack of attention for alternatives to pretrial detention. Another general problem, more or less underlying these 3 more specific problems, is the frequent use or maybe overuse of pretrial detention in the Netherlands. At least a lot of criticism on the Dutch practice is founded on the assumption that pretrial detention is used at a larger scale than it should be in light of the right to freedom and the presumption of innocence. And to underpin this claim, it's often stated that the Netherlands is at the forefront in Europe when it comes to the use of pretrial detention. I will not elaborate on the question whether this is actually true and in how far this is the case, since this will lead us into a minefield of statistics and definition questions. But more important, in my opinion, this will distract us from the discussion in which direction the Dutch practice of pretrial detention decision-making has to develop. Regardless of the exact level of detainees in pretrial detention, also in a comparative perspective, the Dutch practice of pretrial detention needs some critical attention, especially with regard to the three specific problems I just mentioned. During my talk, I will also reflect briefly on the 3 statements the organization gave us to structure the discussion afterwards. But first, a few words on the research project which lies at the basis of my talk today. Most of my talk today is based on the findings of an interdisciplinary research we've conducted in Leiden a few years ago. This research was part of a broader EU-wide research project coordinated by Fair Trials International. Goal of this project was to collect information on the legal framework on pretrial detention and its application in practice in a selection of member states. And this in order to inform the debate on the European level on the necessity of EU legislation in this field, a topic discussed during a webinar earlier this week on Monday. With regard to the Netherlands, our main conclusion was that the Dutch legal framework on pretrial detention generally complied with European standards, but that certain aspects of the Dutch practice of applying pretrial detention fell short of these standards. And these aspects are actually the 3 problems I just mentioned: the extensive interpretation of the grounds, the lack of reasoning, and a lack of attention for alternatives. And although we conducted our research a few years ago, I have no reason to believe that the situation with regard to these problems has improved significantly since then. And most of our findings are also corroborated by later research on the Dutch practice of pretrial detention of our colleagues of Utrecht University as part of the Detour project, which Christine also already mentioned. Let's have a look at the legal framework. Of course, the application of pretrial detention is bound to certain legal criteria, among which the existence of a strong suspicion of a crime of a certain severity, mostly crimes which can be punished by a maximum of at least 4 years imprisonment. And then a strong suspicion is needed. We call it the ernstige bezwaren in Dutch. And of course, discussions in court often focus on the question whether the suspicion in the individual case is strong enough to justify pretrial detention. Of course, this is dependent on the individual circumstances of the case. So it's difficult to assess how courts generally consider this criterion. However, my general impression on this aspect is that Dutch courts usually scrutinize the criterion of a strong suspicion with due diligence. There are other criteria as well. Of course, there must be one or more grounds for applying pretrial detention. Our Code of Criminal Procedure distinguishes 6 specific grounds, but I won't go into detail on that because important for the discussion today is that they in the basis reflect the 4 grounds the European Court also discerns. The risk of absconding, the risk of reoffending, the risk of causing public disorder, and the risk of danger to the investigation. The risk of reoffending as ground for applying pretrial detention is applied most in the Netherlands. As soon as a suspect has a criminal record of a certain relevance, the risk of reoffending will easily be accepted, often without conducting further research into the specific circumstances of the crimes which have led to the criminal record. And another ground which is applied often is the risk of causing public disorder, which ground is formulated in more abstract words in the Dutch Code of Criminal Procedure. You see it on the screen, a suspicion of a crime which may be punished with a maximum sentence of at least 12 years imprisonment and which has seriously upset the legal order. There's quite a lot of case law available at the European level, but also at the national level on how this rather abstract formulation in the Dutch legal framework relates to the more concrete notion of the risk of causing public disorder in Strasbourg case law. For today's discussion, however, the most relevant is that this abstract criterion is easily met in Dutch practice as soon as there is a suspicion of a serious crime, which may be punished by 12 years. And the second part of the criterion, the legal order being seriously upset, is almost taken for granted. So this leads to a practice in which a serious suspicion of a serious crime almost automatically leads to an order for pretrial detention without wondering if the release of the accused would actually lead to any public disorder. And then the risk of absconding. Well, this is quite easily accepted as well in the Netherlands. A lack of an official fixed address in the Netherlands almost automatically leads to the conclusion that there would be a real risk of absconding. Nevertheless, the risk of absconding although easily accepted, is not the ground which is applied most in Dutch practice. And a reason to that might be that Dutch criminal justice do allow for trials in the absence of the accused, although judges, of course, prefer the accused to be present, but there's no necessity for that. And last but not least, the risk of danger to the investigation or the risk of collusion. Well, also easily accepted, even though judges tend to be more critical when time goes by. So this ground plays a more significant role in the first weeks of the pretrial detention, more than in the later stages of pretrial detention. Well, this leads me to a reaction to the first two statements. You can already guess what my reaction would be. It's exact contrary to the situation in Germany, like Christine just told us. The first statement, pretrial detention is mostly a measure geared to secure the presence of defendants at trial. Well, I would say no in the Netherlands. Because of the fact that statement 2 is true, grounds for detention aimed at preventing reoffending and or to protect victims are the main cause of the overuse of pretrial detention. It's exact the grounds I just mentioned, the risk of reoffending and the risk of causing public disorder, that are the main grounds for applying pretrial detention in the Netherlands. Well, then the second problem in practice, I think it's related to the first one, the poor reasoning of pretrial detention decisions in the Netherlands. Although the legal framework contains an explicit obligation to the judge to give reasons for his decision, Dutch practice shows that it does not always actually happen. Despite of the obligation in our legal framework and the case law of the European Court, in most cases the reasoning of pretrial detention decisions is quite brief and in general and abstract terms. Just stating that there is or still is a strong suspicion and quoting one or more grounds for pretrial detention, without a real substantiation why these grounds would apply in the specific circumstances of the case. And of course, this does not have to mean that judges do not scrutinize the criteria for applying pretrial detention seriously. But without a truly reasoned decision, it's hard for the defense, judges in appeal, and the general public to assess the specific reasons and circumstances which were truly decisive. This is especially the case when it comes to decisions to extend the pretrial detention. The initial decision to apply pretrial detention by the investigative judge, usually within 3 days after arrest, is given orally, immediately after hearing the accused, and is mostly reasoned quite well. However, further pretrial detention decisions of the court in chambers or the trial court are sometimes given orally, but mostly given in a written decision, and are often quite poorly substantiated. Recently, the European Court of Human Rights ordered in 3 separate Dutch cases that the Netherlands had violated Article 5 of the Convention by extending the pretrial detention without properly giving reasons for these decisions. So it's clear this is a significant weakness of Dutch practice, which has to be taken seriously. You see the names of the cases on the screen: Hasselbank versus the Netherlands, Maassen versus the Netherlands, and Zoland versus the Netherlands. And then the third problem, the alternatives to pretrial detention. Of course, the Dutch system also recognizes some alternatives for applying pretrial detention, for instance, electronic monitoring, parole supervision, bail, etc. But with regard to bail, although it is applied once in a while, it does not play a significant role in Dutch practice. Despite the possible advantages, a bail system is not really embedded in the Dutch legal culture. And justly or not, in the Netherlands, a bail system is also associated with notions of class justice. All in all, alternatives to pretrial detention do not flourish and seem to be somewhat overlooked in Dutch criminal justice. And an explanation for this may be the way these alternatives to pretrial detentions are legally embedded. In the Dutch system, alternatives to pretrial detention are shaped as conditions to the suspension of the execution of pretrial detention. And this means that alternatives to pretrial detention are available under the same conditions as the pretrial detention itself. Or to put it differently, alternatives to pretrial detention are only available when all conditions for pretrial detentions have already been fulfilled. And on the one hand, this substitution model has the advantage that it prevents for a net widening effect of all kinds of preventive measures. But on the other hand, it also has an important drawback. Alternatives to pretrial detention may only be considered when the pretrial detention itself has already been ordered. So in the Dutch system, alternatives are actually alternatives for the execution of pretrial detention once this is already ordered. And this legal construction may be an explanation that alternatives to pretrial detention are not at the top of the judge's mind. And in addition to that, the lack of attention for alternatives may also be caused by the criterion for suspension of the pretrial detention. Do the personal interests of the accused outweigh the interests of criminal justice? A difficult hurdle to take when the court has already decided that there are sufficient grounds for applying pretrial detention. Now the question is how to improve this situation. What should be done to tackle the aforementioned problems? Before trying to give an answer to that question, it's important to recall the strive for efficiency, which characterizes Dutch criminal justice, which may be a cause for at least some of the identified problems. And although the Dutch system do suffer from all kinds of bureaucracy and hiccups, there is a persistent urge to handle cases as quick and efficient as possible. And when it comes to pretrial detention decisions, this leads to a practice in which in a court session of one day or even one morning, more than 30 pretrial detention hearings are scheduled, after which the court gives a decision in all cases at the same day. In light of this schedule, it's not surprising that these decisions are substantiated quite poorly and that the court does not really have time to pay attention to possible alternatives for pretrial detention. So improving the Dutch practice of dealing with pretrial detention decisions is primarily a matter of battling with a rather excessive strive for efficiency. This being said, I do not think that the way forward in the Netherlands is to amend the legal framework. The current legal framework in the Dutch Code of Criminal Procedure is already inspired by the principle of ultima ratio, pretrial detention as a measure of last resort. The main problem is the way this legal framework is applied in practice with an extensive interpretation of the grounds, a narrow interpretation of the legal obligations, and a tendency to be reluctant to apply alternatives. So I think it's more a question of judicial culture and a certain attitude within the judiciary than a problem with the legal framework. There seems to be an implicit but strong feeling within Dutch criminal justice that crime has to be prevented as much as possible, and that pre-trial detention can serve as a means to achieve this goal. And although such an attitude may be at odds with the presumption of innocence and the right to freedom, it's still quite persistent. And this also leads me to a quite ambivalent answer to the third statement. Current procedural rules allow judges too much discretion to order or extend pre-trial detention. This can be solved by amending the statutory framework, for instance, by posing more constraints on judicial discretion. It's a statement which is difficult to answer or to reflect on. On the one hand, one may argue that the weaknesses of Dutch pre-trial detention practice are caused by the way Dutch judges use their discretion. But on the other hand, I'm reluctant to limit this discretion, since I think discretion is generally a useful instrument in a judge's toolbox. And I think Dutch judges are quite willing to show how they use their discretion and how they have reached their decisions, provided they have an actual opportunity to do so. So we have to recognize that pre-trial detention decisions are even important than decisions during the actual trial. They do actually matter, not only for the freedom of the accused, but also for the outcome of the criminal process as a whole. So I'm convinced that the Dutch criminal justice system has to invest in the quality of the process leading to pre-trial detention decision-making, rather than to amend the legal framework. So to conclude, I hope I gave you some insight in the practice of pre-trial detention in the Netherlands. There are definitely some concerns. A long time, these concerns were somewhat underestimated, with a view to the rather short terms of pre-trial detention in most cases, compared to the terms of pre-trial detention in other European countries. Since the recent convictions of the Netherlands in Strasbourg in Article 5 cases, however, the relatively short duration of pre-trial detention and the many occasions to test, to appeal, cannot be considered anymore as an excuse for the weaknesses in the process of pre-trial detention decision-making. Especially more effort has to be made in giving reasons for pre-trial detention decisions. Subsequently, this may have a positive effect on the interpretation of the grounds for pre-trial detention and the attention for alternatives as well. Thank you very much for your attention. I'm looking forward to the discussion.
Thank you so very much, Jan Krijns, for this excellent presentation. I'll immediately pass on to Ed Cape for his presentation. Ed, once again, welcome to this seminar. You have the floor.
Thank you very much, Andre, and very good to be able to speak to you this afternoon and to engage in something European. So I'm going to talk about the practice of pre-trial detention in England and Wales. And it's important to say that there's been very little research carried out on pre-trial detention over the past 2 decades, but the presentation that I'm giving today is based on a study that was carried out by Tom Smith and myself between 2014 and 2016 as part of the same 10-country study that Jan referred to, which was led by Fair Trials and funded by the European Commission. And this was an empirical research project which involved observation both in our lower courts and our higher courts in just one region of England and Wales. Also interviews with prosecutors and judges and a survey of defence practitioners. Now, the title refers to changing law and changing culture, but in fact, one of the key things that one might observe about pre-trial detention in England and Wales is that it has changed very little, both in terms of law and culture. for about 40 or 50 years. The pretrial detention law was initially introduced in 1976, and it's substantially the same now as it was when it was introduced. And the proportion of the prison population who are in pretrial detention has remained substantially the same over that period at about 12%. So, in fact, rather than a changing law and changing culture, apart from the fact that, as we were hearing in the Netherlands, it's been significantly affected by managerialist ideas, the position has remained fairly stable. That's not to say it's remained stable in a good way, but it has remained fairly stable for the past few decades. So I'll briefly talk about the way in which pretrial detention is governed by law in England and Wales. So it's governed by the Bail Act, as I said, which was initially introduced in 1976. And it has been amended over time since then, but the basic structure is substantially the same now as it was then. Pretrial detention decisions are initially made in our magistrates' courts, which is our lower first instance criminal court. And the initial decision is always made by a magistrates' court. We don't have investigating judges or investigating courts. It's the general first instance lower criminal court. And magistrates' courts, it's important to know, are mostly presided over by lay magistrates, a system which is quite peculiar within the European context, shared only by a couple of other jurisdictions. So mostly by lay magistrates who sit with a legally qualified court clerk. Although in some courts, particularly in busier city courts, we do have professional district judges, as they are called. Pretrial detention decisions may also be made by judges in our higher criminal court, the Crown Court, either at first instance if a case is transferred to the Crown Court because it's a serious case, or in effect on appeal from a magistrates' court. And one other thing to note, I think, is that in magistrates' courts, there is a duty lawyer scheme. So defendants who are appearing at a pretrial detention hearing are almost always legally represented. Now, the law on pretrial detention and bail is a little different depending upon whether a person is charged with a more serious offence, in our terminology, an either way offence or an indictable-only offence. It's different for those categories of offences compared to the less serious offences, which we call summary-only offences. So I'm going to concentrate, because of time and the complexity, on the law relating to the more serious offences. And generally, or almost always, those will be offences which do potentially attract a custodial sentence. And the other thing, by way of introduction, I think it's important to note, is that we use the term bail. So if a person is released from pretrial, does not have pretrial detention imposed upon them, then we say that they are bailed. And it's important, I think, to know, firstly, that bail can be subject to conditions, and frequently is, alternative measures in the sort of EU jargon. And the second point about that is that almost never is there any kind of financial obligation imposed as a condition of releasing a person on bail. So money rarely enters into the decision about whether to detain a person in pretrial detention or to bail them. The one further thing to note is that there are procedural rules, criminal procedural rules, which require the magistrate or the judge to announce the reasons for their decision if they impose pretrial detention in terms that the defendant can understand. But research has found persistently that lay magistrates in particular often announce non-statutory grounds, so they often get the law wrong, and that in about 2/3 of cases, the reasons given are only given in a very formalistic, non-concrete way. So a classic announcing of a decision is we're imposing pretrial detention for fear of further offences. And that may be all that is said by the judge or the magistrate. And then finally, by way of explaining the legal position, the law provides that bail must be considered at each court appearance. So every time a person appears during the course of a case being dealt with, bail must be considered. That's what the law says. But in practice, a defendant has a maximum of 2 opportunities to apply for bail. And after that, they can only, in practice, apply for bail if there's been a relevant change of circumstance. So very briefly, just looking at the criteria by which the decision must be made. Well, we start with a presumption in favour of bail. So a defendant always has this presumption that they should be bailed rather than kept in pretrial detention. And that can be displaced only if one or more of the statutory grounds applies. And the major grounds, there are others, but these are the ones that I'm going to concentrate on today. The major grounds for withholding bail are substantial grounds for believing that the defendant will fail to turn up in court, will interfere with witnesses or with the investigation, or will commit further offences. But note that it does say there have to be substantial grounds. That's what the law says. But in considering those grounds, the court can take into account any relevant factors, but the Bail Act specifically mentions those that I've set out there on the screen. Seriousness of the alleged offence, strength of the prosecution evidence, the defendant's record in answering bail in the past, so turning up in court, the likely sentence if convicted, and the defendant's character and previous convictions. So that's very briefly is the legal framework. So let me say something before I get on to sort of the reasons why I would say that pretrial detention is overused. Let's have a look at some of these statistics very briefly. Now, as I said, the proportion of the prison population in pretrial detention is around 11–12%, and that's been fairly consistent over the past few decades and is one of the lowest in the world. But that, and I think that statistic is often relied upon by governments to say, well, everything is okay then. But we need to have a look at that more carefully. Particularly as I say there, that England and Wales has one of the highest per capita prison populations in Europe. So even though the proportion who are in pretrial detention is relatively low, the absolute numbers are high. So on any particular day, there are about 10,000 people in pretrial detention, and over the course of a year, about 80,000 defendants are remanded in pretrial detention. And a study that was published fairly recently, last year in fact, tried to sort of look at statistics a little more closely. Now, firstly, the decision about whether someone should be charged with a criminal offence is either for the police to take or for a prosecutor to take, in effect, working with the police. And 50% of those people who are charged with the criminal offence are produced from the police station in court in custody. The other 50% are released from the police station and, in effect, are granted bail by the police. So 50% are produced in court in custody, and 20% are then remanded in custody by the court. That's 20% of all of those who are charged with a criminal offence. So we have about 1/5 of all people charged with the criminal offence are remanded in custody at some point during the proceedings by a criminal court. But what we found in the research, and this does fit with other research that has been carried out, is that nearly half of defendants who are placed in pretrial detention at some point during the proceedings are subsequently found not guilty or if found guilty, are given a non-custodial sentence. And that provides the basis for arguing that pretrial detention is overused, is that half of those people who are placed in pretrial detention, as I say, are either acquitted or given a non-custodial sentence. I think we have to be a little bit careful about looking at it from that perspective, because that interrelationship between pretrial detention and sentence, if a person is convicted, is quite a difficult one to unpack. For example, a person who's been in pretrial detention may be given a custodial sentence in effect because they've been in detention, or the fact that they've been in pretrial detention may affect the length of the sentence because a judge or a magistrate may decide to impose a sentence which in effect equates with the time that they have spent already in custody, so that they are released straight away. And there's also an argument which may affect some decisions about sentence, which is that if a person has been in pretrial detention, a court may be reluctant then to give them a non-custodial sentence, let's say some kind of probation or community order, because in effect, if treating the period in pretrial detention as a penalty, they would end up with a greater penalty than they would have had. I hope that makes sense, and I can talk about that more if anyone has questions about that. So what we see is that the law, on the face of it, is fairly strong in the sense that it provides for this presumption of bail rather than custody, and sets out explicit reasons why bail may be denied. But on the other hand, and we also see that defendants are almost always legally represented. But on the other hand, the numbers of people who are held in pretrial detention are too high, particularly if you relate that to that statistic about 50% of those who are held in pretrial detention not then getting a custodial sentence. So why is the use of pretrial detention so high? Well, I will deal with this sort of fairly briefly, given the time available. As I said, our legislation dates from 1976. It has been amended over that time, and what we've ended up with is a very complex and unwieldy piece of legislation governing bail and pretrial detention. And certainly, and this has been consistently found by the research that has been carried out, it does appear to lead to confusion, particularly amongst lay magistrates. As I've said, they quite often announce the reasons for imposing pretrial detention, which are not actually grounds set out in the Bail Act. Secondly, there is a significant information deficit, and this information deficit is of a number of different types. Firstly, prosecutors have to rely on information which is provided to them by the police. Typically a person will be charged with a criminal offence one day, they will appear in court the following day, or even that afternoon. And prosecutors rely on the information provided by the police. And in our interviews with prosecutors, some of them would say that the information that they get from the police is often incomplete or biased. There's an information deficit at the first court appearance because defence lawyers are often provided only with a summary of the prosecution case and only provided with it a short time before the court hearing. And in relation to both prosecutors and defence lawyers, as we heard, I think, in the Netherlands, for prosecutors, they often have a caseload which is far too high for each individual case to be given proper consideration. There's also a lack of information about alternatives to pretrial detention. Historically, a court would have a probation officer in court who could provide information about the availability of bail hostels, for example, which could be relevant for a person who doesn't have a fixed address, or for a person who is accused of a crime against someone else in the household, let's say in domestic violence cases. And because of austerity measures over the past decade, We no longer have probation officers, so we no longer have that kind of information which previously was available. And then also the court, unlike, I suppose, the many European systems, the court only knows what prosecutors and defense lawyers tell them. And there is a very significant reliance on prosecutors as being the ones who are telling the factual situation. You know, so that the defense lawyer has an axe to grind on behalf of their client, whereas the prosecutor is neutral. And so, coupled with the lack of any kind of evidence presented, there is little basis in particular for gauging the strength of the evidence. And that is a statutory factor. It's not a ground for withholding bail, but it's a relevant factor. And so what we in effect see is that the magistrates and judges have no basis upon which to test to assess the strength of the evidence, and yet they're making decisions which rely on assuming that the evidence is strong. So let's move to the statements. So the first is this hypothesis that pretrial detention is mostly a measure geared to secure the presence of defendants at trial. Well, in the English and Welsh system, and certainly from our research, we found that in fact, it was the likelihood of further offending, which was the most frequently cited ground for ordering pretrial detention. So that ground was cited in between 50 and 60% of cases. Now, sometimes it was cited together with other grounds for withholding bail, but taken on its own, that does appear to be, certainly in terms of the reasons given by magistrates and judges, that appears to be the reason that they is most frequently used for withholding bail and ordering pretrial detention. So it follows, moving on to the second statement, that fear of further offending is a very important factor in the overuse of pretrial detention. And I would just go back to the point I made earlier. We've got to link that to the fact that magistrates in particular are making their decision at a time when they don't really have good information about whether the instant offence, the offence for which the person is appearing, whether that is likely to be proved, because they have very little information about the strength of the evidence. I think I share similar uncertainties with Jan about the third statement, because it is true that we don't have any statutory guidelines on how discretion is to be exercised beyond the statutory grounds and reasons for withholding bail. But it seems to me that it's not clear that trying to restrict that discretion would make a significant impact unless very sort of severe restrictions were imposed upon judges and magistrates in terms of making their decision. But having said that, we, in the research report that we produced back in 2016, we did make a number of recommendations. The first was that the law should be amended to make it clear that the fact that a defendant is already on bail at the time of an alleged offence is not an independent ground for ordering pretrial detention. I mean, that is the case. It is not an independent ground for ordering pretrial detention, but nevertheless, it does appear that that's a significant factor in the decision-making of magistrates and judges. Secondly, we suggested that the law should be amended to make it clear that the burden of establishing an exception to the right to bail should always fall on the prosecution. Now, again, that's what the law says, but what we've, in interviewing magistrates, for example, we found that magistrates would tell us that if this was a second application for bail, in effect, they would only grant bail if the defendant could displace the reasoning for the decision to withhold bail at the first court appearance. So in effect, despite what the law says, the magistrates, particularly on second bail applications, switched the presumption, so that in effect it was a presumption that the initial decision was correct unless the defendant could persuade them otherwise. And then thirdly, we suggested that the procedural rules should be amended to make it clearer that courts must devote sufficient time to pretrial detention decision making, and must clearly explain in concrete terms why they have decided to order pretrial detention. In a large proportion of cases, as I said earlier on, the decision that is given is not in concrete terms, and is very often merely a reciting of the statutory grounds for withholding bail, so that the accused and their lawyer have no idea why they in particular are being having bail withheld and being pretrial detention is being ordered. And that both has an impact on the confidence that defendants can have in the criminal justice system generally, but also it affects their ability to make bail applications in the future, because they don't have adequate understanding of why bail was refused on that occasion. Thank you.
Thank you so much, Professor at Cape, for this excellent presentation. Ladies and gentlemen, we have a few minutes for some discussion. And I would like to give the floor first to Professor Morgenstern. I guess that you have been able in the meantime to see some of the questions that were put to you in the chat. Is there a question to which you would like to respond?
Yeah, sure.
Please go ahead.
Very quickly, there was confusion about terms about pretrial and preventive detention, and it's unfortunate that we have to translate it that way. So pretrial detention is what we are talking about at the moment. Remand detention would be the synonym. And preventive detention is a special German thing that is for convicted or for those who cannot be convicted because of mental illness, that are deemed risky and usually comes at the end or beyond a conviction. So that's a totally different thing altogether. So we are talking about pretrial detainees. So that was one thing. And then I had two questions, I think, on the gravity of the offense as a fourth ground to detain. And one question, when can this happen? There's a list of offenses. It's not about the length of sentence that is expected. It's a list of offenses, and it's almost exclusively capital offenses. So if somebody is dead, then this ground for detention can be applied. So it's thankfully only for a limited number of cases. And of course, there's a strong convergence, that was the other question, between the gravity of the offense and the risk of flight, as I said, because when we argue that the length of the expected sentence is the main factor that is taken to substantiate the risk of flight, then those very long sentences, murder, a life sentence, then this converges. And there are only very few cases where it doesn't converge, but there was a Federal Constitutional Court case where this person was a very old person sitting in a wheelchair, and the risk of absconding was just really not feasible at all. And then they said, okay, if this is the case, then you can't order on that fourth ground detention. And indeed, we have like about 90% of all capital cases, pretrial detention is ordered, which means that in some cases it is not ordered. So it's not an automatism. Christina has asked me about when we have a probability for the risk of flight, and I said something about 51%. This is a merely legal theoretical thing saying that if it is more probable that somebody will abscond than be there for the trial or stay in Germany, then it would be sufficient. But this is a merely theoretical thing. It's nothing we can measure, not at all. So not very useful. Yeah, I think there's one more question I should answer by Ilse. And I think she asks for the evidence for the factors substantiating the risk of fright, the social factors. She's saying rightly that this is just assumed and not substantiated in by way of evidence. And indeed, if the information judges have is very limited, and also public prosecutors do not provide much information because they rely on the police, and police just has very limited things to contribute. The thing is that the judges could ask for more information, but they usually don't do that. So that's the first thing. And the defense lawyers often can only help the suspect in the review session. So this is a prolonged procedure, and in the first session, the first hearing, usually this information cannot be brought because defense lawyers are just not quickly enough. But the onus should not be on them. They should be on the judge to see whether there is enough information to substantiate the reason. Yeah, I think that's it for the moment.
Okay. Thank you very much for your answers. Jan, a couple of questions were directed to you.
Yeah, thank you, Andre. Yes, Hilda asked me about statement 1. She said, well, it can be true, not for all, but especially for non-nationals, the risk of absconding will be a ground which is applied most. Yeah, that's definitely true, of course. But still, even for non-nationals, the risk of absconding is often combined with other grounds for pretrial detention. For instance, the risk of reoffending. Then it's based on the nature of the offense. Well, you come in the Netherlands and then now you're suspected of theft or whatsoever. Well, there's a real risk that you will do it another time. So let's base the pretrial detention also on the risk of reoffending. So yeah, it's true. Of course, statement 1 is true for non-nationals. It can be true as well for nationals without a fixed address. But when you see it for the whole population, you see that the risk of reoffending and the risk of causing public disorder are still the 2 grounds that are applied most. And then there was another question of Joep Lindeman. Yeah, that was on the criterion for suspending the pretrial detention, the personal interests of the accused outweighing the interests of criminal justice. Yeah, I think that is not the right. I think you're right, Joep. This is not the right criterion for when you see it from the perspective of the European Court case law. But we could change that that criterion and start with the presumption of release. But still, then I think the real problem is the order of the decision making in the Netherlands. We start by collecting reasons why the accused should be detained, and after that, after we have these reasons, then we are going to think about alternatives. And I think the proper order would be to start with the presumption of release, then consider all kinds of alternatives, and when these will fall short, then consider pretrial detention. Now we do it the other way around in the Netherlands. So that will be my my response to you.
Yes, thank you very much, Jan. But would that also be explained by the provision that we have in the Netherlands Code of Criminal Procedure 67A, paragraph 3, that the detainee may be released when there is no expectation that he will receive a longer sentence than the pretrial detention has already taken. In effect, it is taken as the opposite. Yeah. We will keep you in detention at least for the penalty that you may expect at the end.
Yeah, I think that's true. That suggests that pretrial detention is the rule, and we're only going to think about release after a certain period of time, and it should be the other way around. Why applying pretrial detention? And if there are not good reasons for doing so, well, then start with an alternative. So I was hesitating about the third statement. Should we change the legal framework? Maybe we should we should restructure the legal framework, but we definitely should change the attitude within the judiciary that pretrial detention is the main rule for certain accuseds.
Yeah, but attitudes are very difficult to change with the law. But I think in practice it means that in the Netherlands, most accused have already had their sentence executed before they are finally convicted. That sounds very strange, but it also relates to the fact that we have procedures in 2 instances, and we apply many short sentences. So they've done their time already before the Court of Appeal finally convicts them. It's very strange. I don't think that many other countries can beat us on that. That is not something to be proud of. I do see in all your 3 presentations something in common, that there is quite some stability over quite some decades as to your practice, that pretrial detention remains an issue of inconvenience with uncomfortable aspects, lots of discussion, but little change. And the issues that are there in the 3 countries are different. Ed, there's some questions were put to you in the chat, but I will also add that from a country like the Netherlands, we look at you, England and Wales, with admiration when it comes to the percentage of pretrial detainees. 12%, I think we are around 40 plus. And so how do you do that?
God, it's nice for the UK to be regarded as good in some respects just at the moment. Well, the question there was, one of the questions from Christina was, well, is this because we have this presumption of bail? And I think that is a very important in terms of establishing a mindset. And of course, it's now been established over many years. But, and I think one could link it to the presumption of innocence, you know, that a person is innocent until unless and until they're proved guilty. And so in a similar way, a person is entitled to be released on bail unless and until it's established that bail should not be granted. And I think that that is an important aspect of the mindset. And despite my criticisms, that's very much, when we interview judges and magistrates, that, you know, that's one of the first things they say is, you know, we are very mindful of the presumption of bail. The other question there, very briefly, was in relation to whether the fact that someone may not get a custodial sentence if they have been in pretrial detention, is that because of some sense of atonement or retribution on the part of the judge? I think the first thing I would say is it's very difficult to get judges and magistrates to be absolutely truthful about the basis for their decision making. I think they're always wary about saying the right thing as opposed to saying what they really think and what they really do. But it does seem to be a factor in some cases, the attitude, well, this person has tasted prison and therefore we've now given them the shot that we think they need, so we can afford to deal with them in a way which is not using custody. So I do think that can be a factor. It depends very much on the circumstances, because it can also work the other way around as well. But I think that in particular circumstances, yes, that can be an important factor.
Okay, thank you very much. I think also with regard to the time, we must conclude this webinar. I'd like to thank the three speakers once again for their excellent presentations, which I think gave a great overview of the issues that are at stake with pretrial detention. Pretrial detention definitely is in dispute in all three states and also in the rest of Europe, but the factors that play a role are different. And it seems to appear that very much cultural differences are at the forefront. Thank you once again for your excellent presentations.
Thank you.
Okay, and then I don't know if there's anything from the organizers that must be mentioned, but otherwise we can close and thank you and see you back at what is it, 3:30. 3:30, 3:30. We meet again for the next webinar. Thank you so much. Bye bye.
Thank you.
Bye.
Thank you.
Thank you. Bye.
Bye bye.
Adrian, maybe you should pause the recording.